This conference will now be recorded.
On the SBA's Paycheck Protection Program. Please note that participants are on mute. If you want to ask a question, you can unmute yourself either with the microphone icon on your screen if you're logged on with your computer, or by using *6 if you are on your phone. We are recording this session and we'll make it available to anyone who requests it. So I will get started. We've got a lot of interest in this program. The PPP program has been very popular, and when it was first announced, there were very few guidelines around who was eligible to receive the funds. But following some bad press reports about abuse of these funds, Secretary Mnuchin announced that anyone receiving over $2 million would be audited by the SBA. Also, participants have the ability to return the funds by this Thursday, May 7th, if they feel that perhaps they should not have received them. So NCFC staff has been receiving a lot of questions about this program, and we're very fortunate to have two attorneys with us today who have been advising their clients on the Paycheck Protection Program. Ken Logsdon is a partner at Dorsey and Whitney in Salt Lake City, and Levi Smith is a senior associate at Fredrikson Bryon in Minneapolis. We have asked Ken and Levi to address some of the many questions that have arisen, and they have very graciously agreed to try to provide us with some answers. I'm going to start with a few basic questions that NCFC members have been asking, and then we'll open it up to questions from participants. This question is for Ken. Following Secretary Mnuchin's announcement about audits for those receiving over $2 million, many NCFC members have been asking whether they should return the funds if their current financial situation is good, but realizing that maybe in a few months they will not be in a good financial situation, just given the nature of agriculture and the nature of what's going on with the coronavirus and supply chains, et cetera. So, and again, I'll note that the deadline for returning those funds is May 7th. So Ken, what advice would you give NCFC members in that situation?
Sure thing. And of course, as an attorney, I have to say this is not legal advice. This is just guidance. If you have any need to seek counsel in making a determination, I would strongly suggest you do that, or even your accountant. There's been a lot of accountants that have kind of weighed in on this issue. I know the big four accounting firms are still helping clients make this determination, or at least guide them through it. But this seems to be a moving goalpost of sorts. Most of the audience, if not all of the audience, has already submitted an application, whether just very recently or in the first round of the PPP. And they'll recall that there was a certification that read, quote, current economic uncertainty makes the loan request necessary to support the ongoing operations of the applicant. It's an interesting phrase. Current economic uncertainty was chosen by Congress deliberately because they understood that when applicants were going to be applying for this loan, they were not going to have a complete picture of how things are going to look on the back end of this disaster that we're going through, this COVID-19 impact on the economy. And so I think it is important to be mindful that due to current economic uncertainty, you have made a determination that you think these loan proceeds are appropriate. So I don't think Congress intended companies to get out the crystal ball, so to speak. And yes, though hindsight is 2020, I think it would be unfair for the SBA to apply some kind of a 2020 hindsight analysis. And if they do that, a vast majority of the companies that are taking advantage of this program are likely going to have projections, even with reasonable assumptions, that don't match reality. That's just the nature of business. So I think that's something that must be kept in mind. What's interesting here is the latest developments around FAQ 31, as it's being called, and FAQ 37. This actually came out, FAQ 31 came out on April 23rd. And the FAQ is a simple question posed as, do businesses owned by large companies with adequate sources of liquidity to support the business's ongoing operations qualify for a PPP loan? This analysis and the answer goes on to impose what I'm calling the significantly detrimental standard. Essentially, it asks that an applicant must take a look at other sources of capital that are, quote, not significantly detrimental to the business. And that actually created a great deal of confusion. First of all, that was the first time the Treasury and SBA had spoken to this topic at all since the PPP was implemented. And then there was a lot of confusion as to who was the intended audience. How was this going to be applied? The answer went on to give an example of publicly traded companies being unlikely to satisfy this new standard, but it wasn't entirely clear that this was only applicable to publicly traded companies. And in that same FAQ, the SBA went on to say that lenders are still allowed to rely on borrower certification, and then went further to say borrowers that had applied for a PPP loan prior to the issuance of that guidance, that FAQ on April 23rd, and if they repay the loan before May 7th, or by May 7th rather, they'll be deemed by the SBA to have been made that certification, the necessity certification, in good faith. Now, this came in the form of an FAQ, but to really put this into law, they needed to have this show up in a rule, and that's exactly what happened the very next day. The very next day, a rule came out, and it addressed this FAQ in true respects. It asked a slightly different question, but it was on point. The question was, companies that are backed by or owned by private equity firms, are they eligible? The rule goes on to answer that fact alone does not make that company or applicant ineligible, but they must consider other facts, including the affiliation rule analysis that got a great deal of attention early on in the program. Then the rule went on further to say, regarding the necessity of the loan, quote, the applicant must carefully review the certification. Interestingly enough, they didn't go on to say much more than that, other than carefully review the certification and make sure you're comfortable making that certification. Of course, I would hope that goes without saying, because this is a certification that's being made by a company on an application submitted to the government for government funds. You know, the consequences of running afoul of that could be significant. Nevertheless, that's the only guidance the SBA was prepared to provide. They did not go further and impose what I would call the significantly detrimental standard. So there's been some additional confusion as to why not. Later on in that rule, they do go ahead and impose the safe harbor that was spoken to under FAQ 31. And that was needed to be done because companies can't legally rely on FAQ 31, even for purposes of the component of the FAQ that speaks to the safe harbor. But that has in fact become law. That rule that was published on that Friday was effective immediately and has now no longer subject to public comment and has been kind of baked in stone, so to speak, as of this last Tuesday. Another FAQ followed several days later, early last week, FAQ 37, and that question is, do businesses owned by private companies with adequate sources of liquidity to support the business's ongoing operations qualify for a PPP loan? The answer is an unfortunate and unhelpful. Please refer to FAQ 31. So it seems to be a pretty clear indication by the SBA that this significantly detrimental standard is going to apply broadly. It's going to apply to privately held companies, publicly held companies, and if you look at the rule and tie it into the FAQ, perhaps also companies that have some ownership by private equity firms or those companies that are wholly owned by private equity firms. So that said, there is now this new standard that is lingering. At the very least, even though the FAQs are sub-regulatory guidance, as it's been stated, it is guidance, and it'd be at your peril to ignore it, right? At the very least, the SBA is showing the public exactly how they're viewing this program and how they expect it to be analyzed on the back end. So that's very helpful for your determination. So when it comes to the analysis that a particular applicant is performing and undergoing for purposes of holding on to this loan in light of these recent developments, it is prudent to make sure that you actually do, first of all, an analysis. We do think it's wise to paper it in some form, an internal memo or white paper of some kind that is produced and delivered to the board and making the determination. And the details in that white paper would include projections of how the company would perform, ideally maybe 3 different types, either a base case and a best case and a worst case, with and without the PPP loan proceeds, and in light of other potential sources of revenue, other forms of liquidity, whether it be in the form of credit facilities, whether it be a form of cash reserves, or in some cases, and FAQ 37 speaks to this, whether it be in the form of a well-capitalized parent company. These are the types of things that should be considered and factored into the analysis in making the determination whether the PPP loans are necessary. Again, with the information you have today, in light of the economic uncertainty, if your assumptions are reasonable and your projections appear to be reasonable on their face, I don't think there's going to be much ridicule and focus on those, provided they are reasonable.
All right, thank you, Ken. Another question that we've received frequently is how does a cooperative show good faith in receiving those loan funds? And Ken addressed that a little bit with white papers and memos to the board, et cetera. But are there some other best practices that co-ops could utilize? And Levi, I'll direct that question to you.
Yeah, that sounds good. Thanks so much, and thanks everyone for dialing in today. So really what Ken said, I think is the important thing to take away. We have this guidance from SBA now that says a borrower or an applicant should carefully review their circumstances with respect to this needs certification. And we know that at least with loans for over $2 million, SBA is going to review those and is going to ask questions about them. And they also said that they may look at other loans. They said other loans as appropriate, even if under $2 million, may be reviewed. So I think it's really important that borrowers take this time now, especially in light of this sort of quote safe harbor by May 7th, to review their circumstances both now and at the time they submitted the application, and really create a contemporaneous record that could be shown to SBA, whenever these audits come down the road. No one really knows when that will be, but it will definitely be after the funds have been spent, and there will be some hindsight questioning of it. So what we're recommending, and it'll depend on your particular situation and your particular company, but to Ken's point, some sort of internal report, internal memo to the board, ideally with financial projections and concrete examples of the impact of COVID-19 on your particular business. I think it would be prudent for borrowers to have a board meeting where the board discusses these various topics and memorializes them in the board minutes, and perhaps even adopts a resolution that really sets forth that the board reconsidered the certification, reconsidered the facts that the borrower is facing, and decided in light of that reconsideration to go forward and to keep the proceeds of the loan, and really set forth those various reasons, in the documentation, in the board minutes, and in the resolution, so that there's a record that's created in real time of why the borrower thought that these things would be appropriate. And I think it's important to look, holistically. There's obviously a ton of different factors that go into whether COVID is affecting your particular business. I'll just go through a couple of them. I think there's a laundry list that people could consider. And like I said, I think it will depend on your particular business. But now that we've been in this crisis for, over a month, I think companies can look at what effects the pandemic has already had on their business and operations, and including what sort of uncertainty and perhaps pessimistic expectations may occur if this continues forward, or if there's some sort of rebound in the fall, as some experts are predicting. I think it's becoming perhaps more and more clear that the economic recovery may be more U-shaped than V-shaped, and I think that's something the company should take into consideration, sort of the long-term effect on this, in the long-term effect that COVID-19 may have on their finances. Another thing to think about is, what's the effect that COVID-19 may have on your employees? If you have a factory that has an outbreak, like some of the meat processing plants throughout the country, that could definitely impact both financial returns and public perception of your product, as well as the need to come up with creative ways, such as staggering shifts or start times for workers for social distancing. And that may very well lead to an economic impact, including changes in employee benefits if all of a sudden majority of your workforce has to isolate for 14 days. I think also things to consider would be impacts on your suppliers and customers and their ability to pay your bills that you send to them, both currently and in the future, as those things are predicted to continue over the course of the year. Other things I think to just consider, and again, this is a laundry list, and I'm sure you could think of others that would be applicable to your particular situation. But what's your banking relationship like? Do you currently have debt on your balance sheet? How are your financial covenants that are in your financing documents impacted by additional borrowing or kind of the going forward projections? And is there even the ability to take on more debt as opposed to taking out the PPP loan? I think those are all things that need to be considered. Another thing that we're suggesting clients look at are there any bad facts? If you look at this situation in hindsight, is there anything in particular for your company that rightfully or wrongfully may sort of look bad to the SBA? For example, when you took down these loans, did you also pay significant bonuses to your executives? There's nothing in the law that says you can't do that, but I think if you're thinking about someone looking at this in hindsight, that may be a bad fact that could cut towards not making this certification. So I think for all of those reasons, and because none of us have been through this SBA audit process before on these particular loans, I think it's important to try to do this analysis now, to try to gather as much support as possible now, and really set yourself up in a good position for if and when SBA comes knocking. Now, obviously, this may be this isn't a silver bullet. There's no guarantee that going through these steps now, will ultimately result in SBA agreeing with you. But it's certainly better, I think, than having nothing when SBA comes to do an audit, whenever that may happen. So I'll leave it there and happy to get into more specifics with any questions.
Thank you, Levi. I know there are some timing parameters around spending the funds that you may receive. Ken, I wonder if you could address what's the deadline, or is there a hard and fast deadline for when you have to spend these funds?
Sure. So the original outset, the June 30 is a pretty critical date, mostly because June 30 is the date by which the program is intended to end. When they implemented the PPP in the first round, they fully expected the funds to last a couple months. In fact, it was just a matter of a couple weeks ago where Senator Rubio was asking for replenishing of the funds in the risk that they run out by as soon as the end of May, as he put it. And we found that the funds went much quicker. So from the outset, it was intended for the program to be out there for some time. And we're now dealing with round two, and there are funds being dispersed at this very moment, and they will continue to be dispersed probably over the next several days. If the funds last through this week, they'll go into next week. The June 30 is a date in which the program was intended to end. So if there were any chance, and it's just essentially the chance is probably zero unless the fund is again replenished, that there are funds available come June 29 or June 30, the program would stop dispersing funds on that date. For purposes of applicants and those who have received funds, the most critical clock is the clock in which begins to run the moment you receive funds for the 8-week period in which you're going to be tracking your expenses, your permitted uses of funds, for purposes of determining what amount of that loan is going to be forgiven. So you're going to have a 2-month window there where you do track those funds, and that's the amount that you're going to use to determine what the forgivable amount will be at the end of the day. And if you're getting a loan today, that certainly takes you past June 30. So I would not be terribly concerned with that date. I think that date is more of a distraction for all practical purposes. The more interesting question, however, I think there is what happens in cases where all the loan proceeds aren't fully used at the end of that 8-week period, and it's beyond June 30. What are the uses of proceeds then? Without further guidance, I think the safe assumption is that the uses of proceeds remain what they are stated in the Act. And therefore, even going forward beyond the 8-week period, be prepared to use them in ways that are permitted. There's speculation, perhaps, and we'll probably see more guidance around this issue as the SBA addresses the question of forgiveness, because there remains some ambiguities around that particular process. But as the SBA addresses forgiveness and post-forgiveness issues, I suspect they'll speak to uses of proceeds beyond, in cases where the loan has been termed out and set up to be repaid over the next 2 years. If there are remaining loan proceeds to be used, will a particular applicant be able to use them for other business expenses, such as they would be permitted to do under the Economic Injury Disaster Loan Program? I could see that being a potentiality, but until we see the SBA give their blessing to that approach, I would remain cautious and stick to the very limited uses that are permitted in the Act.
Okay, thanks, Ken. One more question that we've received here, and then we'll open it up to questions from participants. But Levi, we've received inquiries about whether recipients of the loan funds should open up a separate bank account in order to track these funds more accurately. Do they need to be that specific, or what's a good way of tracking where these funds go?
Yeah, I think that's a fair question. So there's nothing in the Act that requires the funds to be deposited into a separate bank account and segregated from the other funds of the borrower. However, we do think that it's probably best practice to do that because the loan proceeds have to be used for particular purposes, and because forgiveness is so closely tied to what the loan proceeds were used for, we believe that it's best practice to put those into a separate bank account so that a borrower can show to their lender when they go to prove forgiveness or seek forgiveness that the money came into this account and it went out for these particular purposes, and the withdrawals from the account match up to these particular payroll records or this rent check or this utility payment. And we think that would probably just be easiest to prove easily through a separate bank account. Now, that said, certainly, companies have sophisticated accounting systems and accountants, and I think someone with a good spreadsheet could track this, the same way without any issue. But just given the volume of applicants who are going to be seeking forgiveness around the same time, I just think the easier you can make this on the bank, the better. And I think by having those in a separate bank account would certainly help that. Again, not required, but somewhat of a best practice that we're advising clients on at this time.
Thank you, Levi. We'd like to open it up for questions from participants, and I'll just remind you that if you're participating through the web, you have a microphone icon. Just click that to unmute yourself. And if you're on your phone, you'll need to press *6. So any questions for Levi and Ken?
Hi, I have a question about the FAQs I think that were recently released with regards to how you calculate the loan payback when you offer someone a job and they don't come back. Do you know how that is kind of mathematically working? Do you just pull that person out and you can use that money for other people? Because that's a real fact pattern that's happening out there, is that people don't want to come back with the increased unemployment rate.
Yeah, this is Levi. I can take a crack at that, and then Ken, be interested in your thoughts. So the only guidance that I've seen so far on that is what's covered in that FAQ number 40, which basically says that forgiveness will not be reduced if there's been a headcount reduction due to the employee not coming back to work, provided that if the employer follows the criteria set forth in that FAQ, which are that they made a good faith written offer to rehire, and that they documented the employee's rejection of that offer. That FAQ does say that SBA and Treasury intend to issue a rule that excludes laid-off employees who were offered, essentially rehired, from the forgiveness reduction calculation. But we haven't seen how that kind of ties into the formula mathematically. Presumably, it will be, I think there was going to be a multiplication for kind of the number of the headcount reduction that would be on a sort of a dollar by dollar reduction to the forgiveness calculation. So perhaps that will just be a different line item that essentially adds that back in or excludes that from the reduction. But I haven't seen anything particular at this point on how to do that calculation.
Okay.
Yeah, I would speak to that too as well, Levi. I echo what you say there. I think there is some confusion in the forgiveness. The forgiveness analysis has some interesting turns to it, and I think the audience needs to be mindful of the difference between the costs that are actually incurred, right? The expenses that are incurred during that 8-week period, and how do full-time employees factor into it. As Levi stated, as this FAQ is described, it's essentially saying the quotient, right? That number that you must actually apply to the total amount to be forgiven will remain unaffected. What does that mean? If you look at the law, it requires that an applicant come up with a total of the amount to be forgiven, but that is not the end of the analysis. And bear in mind, again, the amount to be forgiven are those costs that are incurred and paid during that 8-week period. Now, if you had an employee that decided not to come back, for example, that will affect the total, right? Because those costs and expenses aren't being paid and made. However, I think the FAQ is speaking to the quotient, because in the act it goes on to say further, the total amount of all those costs that have been incurred and paid is the starting point. Then you take the number that's found by taking as the numerator the full-time employee equivalent over that 8-week period, divided by the full-time equivalent of 2 periods. You can choose the monthly or the period average, usually a month, the period average of February to June of 2019, or if the applicant's election, their choice, they could choose January and February of 2020 as the denominator, provided that number is not greater than 1. So you're not going to get the benefit of a number over 1. But whatever that ends up being, that fraction is then multiplied by the total amount that you have actually spent during that 8-week period. So the FAQ is speaking to that specifically. What they're saying is, we're not going to deem you for purposes of having one less full-time employee under the numerator. So I think it's important to keep those two distinctions in place as you look at this.
Okay, let me give you guys a question from our chat feature. If a company has no long-term debt and the ability to borrow, is that viewed as preventing a company from certifying in good faith? I'll give that one to you, Levi.
So was the question, if they don't have debt, but they could go get debt, or they could draw down on the revolving credit facility, was that kind of what it was getting at?
Correct.
Got it. So again, I think it's a facts and circumstances situation. I don't think that there is a requirement that a company, exhaust all other sources of funding. And I think that kind of goes into the overall circumstances. And I think the company would need to, look at what their facility is, what's the interest rate on that. By drawing down on that now to pay employee costs, does that potentially put them into a liquidity issue later on down the road? So I think those are all part of the considerations that the board needs to, take into account when discussing this. But I don't think that just the mere fact that you have an available credit facility automatically says you can't make this certification. And in fact, under a lot of SBA, or under most SBA programs, there is a requirement that the borrower show that they don't have access to other capital. That rule or that requirement was specifically waived for the PPP program under the CARES Act. So I think that indicates that Congress's intent, at least, was not that the borrower go and exhaust all other sources. So I don't think that would sort of automatically make it so that the borrower could not make this certification.
Okay, thank you, Levi. Once again, if you're on your phone, you can ask a question by pressing *6 to unmute yourself, or you can participate just through the web. Are there any questions?
I have a question regarding, it was kind of answered a little bit with setting up a separate bank account. But if we're over that $2 million threshold to where we would be guaranteed to be audited, we thought we needed the money, but then at the end of the year, we still show a profit and we pay patronage to our membership. Is there a space where the government can argue, well, you really didn't need it because you paid patronage, so you should have given this back and now you're going to be in trouble for it? How does one protect themselves from that if that's the case? Does that go back to that setting up a separate bank account to showing exactly what that was used for?
Yeah, this is Levi. I can take a crack at that and would welcome Ken's comments as well. But I think that is, again, I don't think that fact automatically makes it so that SBA is going to say you couldn't make this certification in good faith. I think that goes into all of the different facts that they're going to look at. And I think that's why it's important, where you sit here today, to talk about those things with your management and with your board, and to say, it looks like based on these projections, this could turn out to be, actually an okay year. But I think you could also highlight there's probably some reasons why those projections may not come true. And I think if you memorialize that in your board minutes and in your internal documentation, you at least have the support that you thought about those things, and you didn't just take this money because it was available. Now, obviously, I can't say what SBA is going to think about that, and I think they could come back and say, well, it looks like you guys did fine without this, so maybe you didn't need it. But again, I think it goes back to creating that record now that shows that you thought about these things, and your board still came to the good faith determination that they could meet this certification. Ken, do you see it any differently?
I think that's right. The one thing I would add there is, just by the way the question was posed, I think it's important to keep in mind that the segregating of the funds and having a separate account and tracing and so forth is certainly independent from the good faith analysis, right? The good faith analysis is all about needs. And there's going to certainly be cases, I would hope, that there's other forms of liquidity or capital at the disposal of a particular applicant. And then therefore they should be mindful of, quote, the commingling of funds. But due to the fungible nature of cash, sometimes that is tricky to do. But assuming that you're beyond the good faith analysis, I still do think it is prudent to segregate the funds for purposes of tracking and tracing, especially because that detailed account is going to be required when you go and ask for forgiveness. You're going to have to produce those documents, account statements, etc. So to me, the cleaner, the better.
All right, thank you. We do have a couple more questions in the chat. Let me get to them here. If you received an EIDL, EIDL grant of $10,000, which lowers the amount of forgiveness, does the 75% payroll cost apply to pre-EIDL amount or the post-EIDL amount?
Levi, unless you have something to say there, I would say it probably just take the $10,000 grant piece right off the top, right? And then they apply the math accordingly. But we don't have enough information on that particular question. I strongly suspect over the next few weeks here, we're going to see FAQs whereby the SBA provides ideally hypotheticals exactly of how the forgiveness is supposed to be calculated and work. And as they've done in calculating the loan amount and how the EIDL program or EIDL program, how you prefer to pronounce it, will affect the analysis, they have factored that in. But I don't know if you have anything else to add there, Levi.
No, I agree with that, and that's I agree with your most likely take on that. Subject obviously to getting some more guidance on that.
Okay. If a company meets the requirements of the loan, but they only spend close to 75% of the loan amount on payroll, is none of the loan forgiven at that point, or is there a prorated amount that will be forgiven?
I'm happy to speak to that, Levi.
Yeah, please do.
I think there's confusion out there. I've seen this a couple places, and I've been asked a couple times if less than 75% of my uses of proceeds goes towards payroll costs, is my forgiveness amount zero? And I don't know where this comes from. Maybe perhaps the law is slightly ambiguous on this, but from the further guidance we've seen by the SBA, I think the proper way to approach the percentages analysis is that you take the total amount that you have spent over that 8-week period, assuming towards permitted purposes. And to the extent that no less than 75% of that amount goes towards payroll costs, the applicant should be prepared and could reasonably expect the full amount to be forgiven. If, on the other hand, less than 75% of that total went to payroll costs, there would be a reduction in what would be forgiven, such that the final calculation would be whatever is in fact forgiven, no less than 75% of it will be payroll costs.
Okay, thank you, Ken. I'm going to paraphrase one of these questions a little bit, I think, if I'm understanding it correctly. If you have an affiliated group, let's say with 3 members, two of the members are too large to participate, but 1 member is eligible. How does this work under the program?
Yeah, I can speak to that. So basically, if you're saying that you have affiliates, and if there's 3 companies that are all affiliates, and collectively between the 3, you have over 500 employees, the affiliation rules are complicated, but generally speaking, that would mean that none of those companies would be eligible for participating in the PPP program, because each company with its affiliates has greater than 500 employees. And that's subject to, some exceptions and some factual, situations that may change that analysis, but that's the general rule.
Yeah, with the interesting twist there, and I'll add to that, Levi. There's an FAQ that spoke to some of the affiliate waiver concepts. If you recall, in the law, there is waivers of the affiliation rule for hospitality and food services businesses that are actually funded by SBICs. And there was an FAQ that actually spoke to how do you in fact calculate the affiliate analysis in those situations where you have, let's say, for example, 1 company among 3 companies that is funded by an SBIC, the other 2 that aren't, and how do you run the analysis? Well, essentially it said you take the SBIC funded company and you treat it independently without regard to the affiliation rule, and see if it's under the 500 employees, and then you move forward with that in mind. As for the other 2 companies, interestingly enough, they do not get the benefit of that exclusion. They actually have to include the employee base of the other company, that SBIC funded company, and as a whole, determining whether they run afoul of the 500 employee or less analysis or alternative standards. Bear in mind, it could be a small business concern, including with all affiliates, or the alternative size standard is another way to do it. But for simplicity, I'm just referencing the 500 employee or less. And so that was an interesting twist, because up to that point in time, there was this assumption that if an entity got carved out because it received essentially a free pass on the affiliate analysis, surely its affiliates would get the benefit of that carve out. And that is not the case. So that is something to be mindful of. Okay,
thank you. I do have another question in the chat, but I want to give a chance for folks who are on the phone or on the computer to ask a question. Again, if you're on your phone, *6 to unmute. Okay, I'll go back to the chat then. If audited, will the SBA look at the certification made at the time of the application, or whether or not the actual use of the loan was for the same reasons used to make the certification? The concern is that 6 months from now, we'll have the benefit of time and we will realize that we didn't actually need the loan. I think we've sort of addressed this question previously, but Ken and Levi, I wonder if you have anything to add to that.
Yeah, so this is Levi. I guess with the overarching, sort of caveat that the loan proceeds need to be used for permitted purposes. So just so that's clear, I think that SBA, will look at the time the certification was made and the economic uncertainty of the company at that time the certification was made, and that's why we're recommending, especially in light of this sort of second chance, to take another look at it with this May 7th deadline. To sort of have the company confirm that they still feel they can make that certification. But I don't think it would be appropriate for SBA to look to see how the year, shook out, provided that you're not projecting or don't have reason, good reason to believe that you're going to be okay where you're sitting now. I think SBA should look at the time that the certification was made because that's when you applied for the funds, and that's presumably when you felt that there was this uncertainty.
Yeah, I agree, Levi, and you made a very good point, which to me, I like to make this point as well, and it's unclear how it should be viewed. But interestingly, with the safe harbor notion, whereby companies are allowed to repay the loan by May 7th, surely that's intended for those companies that certainly couldn't satisfy the good faith analysis, or perhaps didn't give it enough, didn't give it a good overview and a deeper dive. But upon doing so, they determine perhaps maybe they are coming up short. What isn't clear, however, is how does that change the analysis for companies that have already certified on the application, have received funds, and they did do it in good faith, and they perhaps could even satisfy that higher bar at the time of, but between then and come May 7th, things have changed that affect the analysis. I hope that there's not this imposed standard whereby, because of the time difference there between the certification on the application and the safe harbor that's intended to be for companies that didn't actually have a good faith analysis out of the gate, to potentially be used against companies that in fact did, but because of the time difference, things have changed and perhaps they wouldn't come to the same conclusion. Of course, the very conservative approach is, and I think what would be wise to do, is if you have any concerns in that respect, just take a quick look at your underlying assumptions and projections that you made a couple weeks back when applying for the loan, and make sure there's no material deviations due to new information. That way, then you can be comfortable to know that you're in good shape, even if the time of analysis is imposed on companies across the board to essentially be the May 6th/7th date.
Okay. Can a lender rely on the borrower's certification? And I'll toss that one to you, Levi.
Yeah, so SBA has issued guidance that for purposes of perhaps if the lender would be liable if a misrepresentation was made or a miscertification was made by the borrower, SBA has confirmed that the lender is allowed to rely on the borrower's certification. But one thing that I want to be clear about is that just because the lender has accepted the application and has funded the loan, that doesn't sort of relieve the liability or the obligation of the borrower to make sure they could make that certification. I've had some folks say, well, the lenders didn't question this and they know our financials and they were okay with it. I don't think that's going to carry the day with the SBA, because ultimately it is the borrower's certification to make. Although for lender liability purposes, the lender will be able to rely on those certifications, likely absent any sort of egregious error or something that they maybe knew about, but decided to fund over anyway.
Okay, thank you. Again, open to taking questions. Any questions from participants?
Yes, I had a question. It appears that Senator Mnuchin is come up with a liquidity justification as an objective test for qualifying for the loan. The others, the current economic uncertainty, is fairly subjective as well as significantly detrimental. Do you have any guidance on how you would document the liquidity measurement, liquidity ratio analysis, cash burn analysis, and also would that analysis need to include revolving line, available amounts under revolving lines of credit?
Yeah, this is Levi. I can take a stab at that. I think, again, this, not to sound like a broken record, but goes into the kind of the overall analysis of the circumstances. And I think those are all things that the company should consider. We don't have great guidance about right now if, there's not a bright line rule that if you have, $5 million of availability in a revolving credit facility, you can't make the certification and you had to use those funds. So again, I think this goes into the overall analysis, including, may you need those funds to get through the rest of the year if things turn out to be, worse than you were expecting. So as to not get into some sort of liquidity pinch down the road. Ken, feel free to add in any thoughts on that.
Yeah, it's we're trying to give as much guidance on that particular question during this entire call, but I appreciate the question being asked again because it is uncertain, right? It's a fair question that doesn't have a very complete and clear answer. I think one way to look at this is kind of tackle this backwards, meaning what happens if you don't get the PPP loan proceeds? The very first question needs to be asked in that situation is, do you reduce staff? Will there be employees that will be terminated? Or will salaries be reduced? If the answer to that question is a comfortable no, then I would say be very cautious proceeding without repaying the loan in full because it may not be for you. If the answer to that question is yes, that's really the heart of it. Then it comes down to materiality. And when you bake in your assumptions and you do projections, you want to be able to lay out how many employees are going to be impacted in a worst case, a base case, and best case scenario. And the more particular, the more quantitative, to me, I believe, the better. But that should be the real focus of the analysis with the information you have at hand.
Okay, thank you. We have just a few more minutes, so encourage you, if you have a question, please speak up.
I have a question here on just your view of a current scenario. I think a lot of ag retailers find themselves in, and the fact that we've put in a crop or helping put in a crop here, and we've had a lot of activity both from selling inputs as well as not only maintaining employment but probably posting part-time positions to get all of the work that needs to be done here in this short amount of time. As an essential business, just kind of asking for your perspective on what that scenario looks like when we think about that current business activity portion of the certification. Could you talk to that scenario? Because I think it's one probably a lot of us are probably in.
I think the question is, and correct me if I'm wrong, does the fact that a particular applicant is, quote, an essential business, does that factor in? Is that the question?
That is the question, and the significant amount of labor and employment that's happened here over the last 4, 5, 6 weeks.
Sure. And Levi, you can speak to it, but I guess my thoughts on it are, unfortunately, there's nothing in the law nor in the guidance that we've seen that speaks to the particulars of the applicants. There's nothing that is signaled that the SBA is going to treat an essential business differently from any other business. That being said, in my experience, the essential businesses tend to be impacted in ways that are unique and I think important to paper and to highlight when you're doing the analysis. For example, in the farming industry, in the meatpacking industry, there's some interesting and particular challenges that those industries are facing due to the labor force and how that force is being impacted by COVID-19. And the impacts for those particular industries, if I'm not mistaken, from my perspective, are somewhat delayed, right? I think most of the impact on the economy so far has been kind of the front lines of consumerism, if you will. It's been the retail, it's been the hospitality, it's been the food services. But we're finding, even just in the very recent past here, we're talking just a few days now, how this is really starting to affect the kind of the underlying economy when it comes to processing and farming, et cetera, especially the impact it has on the labor force and the ability or the inability for these companies to be able to rely on being able to remain open or rely on a labor force that isn't significantly impacted by the virus itself and therefore unable to work. So I would say those are the types of things that you bring into the analysis. And because of your industry, if there's something unique, highlight it, incorporate it, and make sure that it's clear that there's some unique features due to the industry that aren't applicable across the economy, but have a significant and material impact on the types of jobs that might be saved or not, absent these funds.
Yeah, and I think, Ken, I agree with all that. I think the only thing I would add is if you're saying just because of our seasonality, right now is our busy time of the year, we're selling a lot of inputs, and our revenues actually look pretty good right now, and we're actually hiring folks, over the next 8-week period. I think that's something that you need to think, pretty hard about and take into your analysis, because if the purpose of the loans are to keep people on your payroll, over kind of the next 8-week period after you got the loan, and you're saying, well, we're actually having, sort of a really good year, during this period, and we're actually hiring people, and even without these funds, we wouldn't be laying people off or cutting salaries. I think that's something you need to take into consideration. I don't think that's necessarily, a fatal fact, because I think you can make the argument that, well, spring is really good, but depending on what, prices look like this fall, this could end up being actually a really bad year. But I think that's something that SBA is probably going to look at. That's one of the facts that they'll consider at the time you made this application. And I think it's something that needs to go into the overall analysis and be part of that. Because I guess to, someone who maybe doesn't know the seasonality of your business, it may look like to them that over this 8-week period, you guys are actually doing pretty good. And you used sort of taxpayer dollars to fund payroll, even though you had, plenty of other funds to do it. So I think it goes into the overall analysis. Again, not a bright line rule, but definitely something I think you want to think about. And I think you want to think about now and have the record of it so you can show SBA, hey, we thought about it, but for these reasons, we still decided that we could meet this need just based on, needing to preserve capital for getting through hard summer months, or what if our, entire workforce gets COVID and is out for, 14 days or an extended period of time. I think those are all the facts that need to go into the analysis as well. But I think it's important that you are thinking about it, and I think that's a fact that needs to be addressed.
That was a great point, Levi.
I think we have time for one last question, and there's one here in the chat that I don't think we've addressed. How are capital lease payments considered in the forgiveness process? Would the interest portion only be included?
I can speak to that if you would like, Levi.
Sure.
Yeah, so the law speaks to real and personal property mortgages. It's a loose reference to essentially secured obligations, which is important. I've had the question asked, what about unsecured debt? Do you get to pay interest on those items? To me, my answer is probably not, because the Act doesn't speak to that directly, because it does speak to items that are subject to mortgages or otherwise are secured. For purchase money and capital lease items, you certainly would only get the benefit of interest, because interest is expressly mentioned. So the answer is only interest, non-principal payments, even in those situations.
Okay, thank you, Ken. Well, I want to thank everybody who tuned in to our webinar today, and I especially want to thank Ken Logsdon with Dorsey and Levi Smith with Fredrikson and Bryon. They've been very generous with their time and expertise, and we really appreciate that. So hope to talk to all of you soon on a future webinar. Thanks and have a great day.
Thank you.